Hello, welcome back to another LSS Property Beach tutorial. Perhaps the first LSS tutorial given from underneath a tree. Um, I'd like to start by acknowledging country, the people of the Kulin Nations, of the traditional owners of the land on which I meet online today. I'd like to pay respects to their elders past and present. Also, we have some of our very cool sponsors, Cause Chambers Westgarth, Clayton Utes, Gilbert and Tobin, and King and Wood at Mallisons. Academic integrity statement, as usual. The Monash LSS strictly condemns academic misconduct and has a zero tolerance policy towards persons who are found to have breached their academic integrity by misusing our educational services. The student tutorials program is purely supplementary, aiming to provide extra assistance to students. Students should primarily engage with faculty-run seminars, workshops, and tutorials, etc., as STP resources cannot be solely relied upon for learning. While our LSS tutors work hard to deliver value, unit content, reading guides, and the law can all change, although it's probably not going to change in Property B. Consequently, students must exercise their own discretion when using our resources. When there is an inconsistency, students must always refer to their chief examiner and faculty staff. Awesome. Now, topic 3, mortgages. Probably the most important topic in the whole unit, I regret to inform you. There are some things in the reading guide I will not really cover today. So, the clogs on the mortgagor's right of redemption, inequities protection of the mortgagor through its unconscionable conduct doctrines, etc., that you would have learned about and touched upon in Contracts B. Those are relevant because mortgages are contractual documents too. So, you can vitiate a contract. Can't see it being particularly relevant in your unit, but of course, please do go over it yourself and ask your faculty or listen to what they have to say. The other parts, such as the nature of a purchaser's interest when buying from a mortgagor and an injunction, prevent a defective sale, which can be sought by the mortgagor, which are really better left off until later parts of the unit, in which case they'll become hyper relevant. I can't really teach it to you in the sufficient depth without you going through the other topics first. So, yeah, that'll be my approach. Ultimately, in my experience, an important caveat, the crux of this topic is the mortgagee's right to exercise the power of sale, but upon default of the mortgagor, sorry. I'm sure in my slides I've messed up mortgagor and mortgagee a lot. I'm so sorry. Uh, you must understand that the mortgagee's power of sale arises and the duties, or how it arises rather, and the duties of the mortgagee in exercising this power of sale. Again, ultimately, what you are really learning is whether there has been a defective mortgagee sale of the mortgagor's property. This is really important as a mortgagor will have an equity to set aside a fraudulent transaction if there's a defective sale. Store that in the brain, it'll be coming up later and you'll be getting assessed on it in your exam most likely. Understanding how this equity arises is critical for later topics, as this is an unregistered interest in property, which may compete against other interests in the same property. Will the mortgagor win? No, the bank probably will. Alternatively, you may simply be advised to consider whether there had been a defective sale as a standalone question, as I may or may not have been in my assessment. The rights of mortgagees on default. I'll run through these very quickly. The mortgagee has 3 key rights, at least for our purposes. I'm sure there's more out there, against the defaulting mortgagor. Action for debt, that's what they can do. Contracts B, mortgages have a contractual element, so a personal covenant to repay will be within these documents. So it's always possible that the mortgagee could sue the mortgagor in debt to recover the funds. Of course, in practice, this is rare, given mortgagees will always opt to exercise their proprietary interest in the property, their security interest, to recover the debt, rather than relying on their contractual entitlements. Yeah, I mean, that makes sense. If you've got a $1 million mortgage and there's a property attached to it, of course, why would you not exercise that? You're probably not going to sue the person for $1 million in debt because they can't really pay it. There's a reason they've defaulted on their mortgage. It's because they're poor. Well, financially stressed. Do note that this action becomes particularly important if there's a shortfall after the sale of the land. where the sale price does not cover the debt owed to the mortgagee, and the mortgagee can recover the rest from the mortgagor personally at their own suit. It's really important to note, and we'll be going through that as well in more depth later when you start to learn about registered mortgages and perhaps even fraudulent mortgages and the situation that arises there. Second, the mortgagee may enter into possession of the land or bring an action of ejectment to recover the land. What a lame remedy. You can march on the land, claim the rents, etc. But what we're really interested in is exercising the power of sale. That's why they've taken the mortgage, is to have that power of sale. And we're going to talk about the circumstances in which it arises. Aha. So, on your given facts, you will have a mortgage. Your first step will be to determine whether the NCC, the National Credit Code, applies to a particular mortgage that you have on your facts. And the reason you're doing that is if the code applies, different rules to the general TLA apply with regards to the arising of this power of sale. So I'm going to go through a bunch of statutory provisions now, which hopefully will help you determine whether the NCC applies to a particular mortgage. And then I'll go through the consequences of that naturally. Section 7, subsection 1A provides that the NCC applies to a mortgage if it secures obligations under a credit contract. Cool. Section 4 provides that a credit contract is a contract under which credit is or may be provided. Now, it's not an awfully informative section. Usually when you're defining something, you shouldn't have the same term as it that you're trying to define in the definition. Anyway, it's probably just some VCE rule. Section 3.1 defines credit, which is probably the most important one, as the payment of money owed by a person to another is deferred. So when you say, I'm going to pay you 100, but I'm not going to do it now. I'm going to do it in 2 weeks. That's a debt because they have a right to recover that money, but it's not their property yet. Or a person incurs a deferred debt to another. I'm not too sure what the difference between those two are, but it'd be something smart. Yeah. Deferred payment will be more than sufficient for your understanding. Yeah. Section 5.1, the key provision, provides that the NCC applies to a provision of credit if, when the contract is entered into, the debtor is a natural person. So the person who's taken out the debt, who will be the mortgagor in our scenario, is a natural person. Should have no trouble finding that out. Actually, fun fact, I'm not too sure if a corporation is included in that. Maybe not, because natural is not a natural person is not a corporation. Corporations are unnatural people. So that's a good to keep in mind, just in case that comes up. I've never seen it. And the credit is provided or intended to be provided wholly or predominantly for the following: for personal, domestic, or household purposes, to purchase, renovate, or improve residential property for investment purposes, or to refinance credit that has been provided wholly or predominantly. What's it called? That should say to improve residential property. I must have just neglected to put it in there. So, double I and triple I are about credit related to improving residential property. The colloquial term for that would be a renovation. The credit, a charge is made. The other requirement is that a charge is made for providing the credit. Now, this does not mean a charge is in another security interest. A charge is a type of security interest, but it's more so talking about a charge, like an interest rate. And finally, subsection D, the credit providers provide credit in the course of a business of providing credit, or incidentally to any other business of the credit provider. Usually you'll have a bank. There'll be no trouble there. However, that last bit, incidentally to any other business of the credit provider, think of some examples. Okay, you go to a shop I don't know, you're not very fashionable, you head to Culture Kings. Um, you go to buy something, but you don't have the money. And the Culture King says, "Oh, you know what? That's okay. Um, come back and pay the rest off in a couple of weeks." Credit, and that's provided incidentally to their core business of selling skinny jeans. Anyway, Section 5.4 provides that the predominant purpose which credit provided uh, is towards one of those, what's it called? Uh, yeah, so predominant purpose is more than half. And that more than half has to be applied to one of the above circumstances from I to triple I. Now, Section 6 contains a slew of exceptions, contracts where the NCC does not apply, so mortgages where the NCC will not apply. I've never used them, but it is always advisable to be familiar. It's all about different bank facilities and different debt facilities. I don't look, have them in your notes just in case they come up, but um, this is not a capital raising course about the different types of instruments that financiers can use. So I wouldn't stress too much about it, but just have it in your notes, if just just for personal satisfaction and calmness. So there's some presumptions too which come up. Um, Section 13.1 provides that in any proceedings where a party claims a mortgage is code protected, it is presumed to apply unless the contrary is established. So if there was a mortgagor wanting to say, there's been a defective sale of my property, and they allege that, the NCC applies, it'd be presumed so, unless the mortgagee can prove otherwise. Section 13.2 provides that the NCC is presumed not to apply if the debtor, the mortgagor in our case, declares before entering into the contract for credit that the predominant use of the debt will not be for a code protected purpose. So yeah, say if they declare, I'm using this money for my business, that is not a code protected purpose. Or if they are speculating on the capital market, that's what they're telling the bank they're going to use the debt for. That is not a code protected purpose either. Investment in shares, etc. Section 13.3, however, provides that the debtor's declaration is ineffective rather, if when the declaration is made, the credit provider or related person, so really the bank or its bank employee, knew or had reason to believe, or would have known or had reason to believe, if the credit provider made reasonable inquiries about the purpose for the credit, it would in fact be wholly or predominantly for a code purpose. Okay, those are all the sections really determining whether the NCC applies. Really, it'll probably make more sense once you apply it to a practice question, which we will do later. At the conclusion of this, once you understand it, hopefully you will have determined whether the NCC applies to regulate the mortgage and the mortgagee's power of sale. If it does not, then you'll apply the general TLA, Transfer of Land Act. I probably should have gone over this at the start, but I'm sure you're all across the nature of a mortgage on the Torrens land. It's not a transfer of the property like it was in the general law land. It's but a security interest noted on the title. So, and that's why the TLA applies. It's Torrens land. It's a Torrens mortgage. Now, okay, so you've established whether the NCC applies or does not apply. If it doesn't apply, you have the TLA provisions section, and this is about when the notice requirements, and when after default, the power of sale arises. So Section 76.1 provides that if a mortgagor's default continues for 1 month or any other period as is expressly fixed, note in your factual scenario, look at the contract of mortgage, the memorandum of mortgage. What does it say about this particular matter? There may be something. If it's silent, you just assume that the TLA minimum or standard applies to 1 month. And after that, the mortgagee may serve notice on the mortgagor. Section 77.1 provides that the default is not remedied within 1 month of the mortgagee, after the mortgagee serves notice, or any other period as is expressly fixed, the mortgagee may exercise the power of sale. So after failing to remedy, at the way either a month or whatever else they agree, before they exercise the power of sale. So you get the first step after a month or any other period as they agree to, they can serve the notice. And, in that notice, they can either provide the minimum after providing the notice will be a month or any other period before the power of sale arises further from that notice. This is not necessary information as well, but I've just noted below that there's an interesting interposed contracts fee. The time expressly agreed is obviously a contractual term. It cannot be so short that it effectively amounts to a penalty clause for default of an obligation to pay the mortgage. So if you fail to pay the mortgage, your contract probably can't say we can exercise our power of sale after 1 day. That would be a drastic remedy, a drastic clause in response to a failure of the mortgagor to pay, and that'd be impermissible. But I don't think you really need to know that. But it's just good to know for life and stuff. Oh, the NCC again. This is one of my least favorite statutes. This statute sucks. It is so bad. Why would you make it, Kevin Rudd? The NCC is silent, silent, silent. Yes, silent on the amount of time after default when the mortgagee can serve the initial notice of default. This means that Section 76(1) of the TLA therefore still regulates the notice requirement. Now, you really must understand this. Even if you've provided or held the NCC applies, with respect to this first requirement, the provision of the notice of default, Section 76 will apply because the NCC is silent. However, the NCC is not silent on how long after providing that default notice the mortgagee must wait until exercising their power of sale. It's a minimum of 30 days. You cannot contract out of the NCC. There's some provisions against that in Section 191 of the Act. So minimum of 30 days, whereas if you see in the TLA Section 77(1), which is the corresponding provision, says again, any other period is expressly fixed. So the NCC does provide a little bit more protection to mortgagors who have defaulted. All right. Contents. If only the TLA applies, the default notice will be valid so long as it, one, correctly identifies the mortgagor's default, so it says you've defaulted, and two, provides an opportunity for the mortgagor to remedy. And that's wild. So that's all that's required. In wild, which is what you'd know the case for, but that's the general principle up there. In wild, it was held that the notice was still valid despite the mortgagee inaccurately stating the amount of the default. In other words, it accurately identified the event of default, which is sufficient, but it just misstated the amount of default, I suppose, the amount of arrears. Said that the mortgagor was in default by $6,000 when it was $4,000, something like that. Still valid. What about under the NCC, you ask? Much more rigorous. There are very strict notice requirements under Section 88 of the NCC. You should read them. You should. Yeah. But however, usually a question tells you to assume that these sort of formalities are being carried out with. Property B is a conceptually difficult unit, in my view, or relatively. The examiners want to assess your understanding of the concepts, not your ability to go through a statute, a really long statute, and go tick, tick, tick. You're not in first year, unfortunately. Yeah, so I have them in your notes. Cool, but really don't want to give out bad advice here. I've never used it. I did lots of practice exams, so I would have seen it, but it usually just says, oh yeah, the notice, the contents are okay. And then there might be something wrong with the time fixed for the mortgagees, the right of sale. Might fix 20 days or something like that. But anyway, now the most important part, the mortgagee's duties in conducting a sale. So what we've just established is that the right of sale exists. Splendid. The bank can sell your property and you will be imminently homeless. That's really sad. But anyway, fortunately for the mortgagor and you, if you find yourself in this position, is that the mortgagee must observe two key duties, or else it will have a defective sale and the mortgagor will have an equity. Remember, That's important for later topics. I'll give you a spoiler. An incoming purchaser from the mortgagee, sorry, even if there's a defective sale and the mortgagor uh, has an equity, they'll wipe the floor with the mortgagor. So the person, basically, the mortgagor is pretty hard done by. Um, what they can do, and you'll learn this later, this is great. They can go to court and get a $50,000 and spend like 30K on getting an injunction. Um, that's effectively useless because it takes so long to get to court anyway, that the purchaser will have registered by then. And yeah, um, it's pretty stiff. So basically the mortgagor will have an equity if the sale is not conducted properly, and it's useless. Um, so the bank wins, and the purchaser from the bank wins. Um, must be that way. The court in Henry Roach held that Section 77 imposes two separate and cumulative duties on the mortgagees, which must be complied with. I've repeated myself. First, the duty of good faith. This imports a subjective requirement of honesty, fairness, and a lack of fraud or collusion. That comes from Justice Murphy and Gold Cell nominees before he was on the High Court. Yeah, quite an illustrious judge, Murphy. Quite similar to Kirby, that he didn't. It was quite left of centre. Very interesting. Anyway, now you'll remember good faith from Contracts B. I'm really sorry to bring up Contracts B so many times. So please don't be put off. I didn't love the unit. But yeah, good faith, what it's essentially about is preventing the person who holds the power from using that power beyond the purposes for which it was given. That sounds convoluted, but I'll put it in the context of a mortgage. The mortgagor has been given a power of sale in consequence of default. They can use that for one purpose, that is to recover their debt and sell the property for as much as possible. Anything other than that is invalid. That's the reason why they have the power, and that's what they must use it for. So keep it in mind. So you'll have cases where the mortgagee flogs off the property at a considerable undervalue just to get themselves paid out. Does that show a lack of fairness? It very much could do. Now, second, the duty to have regard to the best interest of the mortgagor. This is probably the biggest one, not the biggest one, but most commonly litigated. There was a slight controversy as to the test. However, it has been settled, I believe, check your lecturer, that this requires a mortgagor to take reasonable steps to obtain the best price for the mortgagor. Oh, God, I've messed it up again. It has been settled that this requires a mortgagee to take reasonable steps to obtain the best price for the mortgagor. So that's MBF Investments versus Nolan. You can see how the mortgagee obtaining the best price for the mortgagor is quite important to the mortgagor. Why? Well, they get the residue. So, if there's a $500,000 mortgage over $1 million property, if it sells for $1 million, the bank gets 500 and the mortgagor gets to keep the other 500. It's a great investment, just halving your money. Awesome. Case law, very important case law to this particular part of the unit. So I shall go through it in some way for you. Henry Roach Petroleum Proprietary Limited versus Credit House. Henry Roach was the mortgagor of, really, you can look at the credit house, you can probably presume it's going to be the mortgagee rather, and you'd be correct. Henry Roach was the mortgagor of 51 acres of land, which was subject to a sale by Credit House, the mortgagee. They've defaulted, of course. The plaintiff asserted that the mortgagee improperly exercised their power of sale. It breached the best interest duty. There's an ambulance going past, hopefully that's okay. Breached the best interest duty, did they? And that's what we're going to discover. The plaintiff suggested that the mortgagee failed to advertise appropriately and draw attention to the special characteristics of the land. It was the only approved oil refinery site in Australia. Now, really, if you read the judgment, you'll find that there was no market for anyone who wanted to operate a oil refinery in Australia. The reason why is because our labour costs are so high. So you may as well go overseas. And to put it in very neutral terms, there are people overseas who are willing to supply labor at a much more competitive rate. So yeah, no one wanted the property to use it as an oil refinery. The energy would be too much to produce. So all they could really do was sell it as land, which drastically reduced its value according to the estimates. So Henry Roach had some estimates that it's worth millions because you can refine oil, but no one wanted to do that. So it was just a block of land with some fixtures on it. So it sold for not much, and yeah, went no way towards paying back the debt. Anyway, the court found that the mortgagee did not breach their duty stacked in the best interest of the mortgagor. They obtained the best price they could. The court regarded the mortgagor's advertisements as sufficient in the circumstances. They had floated the idea to international capital markets and investors and etc. But there was no need for them to continuously push for the international investment. It was not coming. Yeah, no one would. Why would you open up a refinery in Australia? It makes no sense. Broader principles, though, there's some really important ones that come out of this. Suggest that there is a duty to advertise if a mortgagee is going to be acting in the best interest of the mortgagor. C.F. Vasiliou, though, which I suspect is probably the more authoritative decision on that point, we'll go through that in a couple of slides' time. The mortgagee must take steps to get a sworn valuation that is required for the best interests duty. You cannot get a guesstimation from a real estate agent. They've got no clue. The mortgagee does not have to wait for a more propitious, I think that's how you say that, time to sell. So they don't have to wait, for instance, for the market to recover and property prices to boom. They can flog it off pretty quickly. However, at the same time, they cannot sell at any old price just to get themselves paid out. Vasiliou, I haven't really gone through the facts here too much. Just because Vasiliou was a crazy man, he was alleging all sorts of impropriety on the part of the state and the bank and even the judiciary. So it's a good read. But what really comes out of this is the principle that the court said that the failure to advertise was not necessarily determinative of a breach of duty with regard to the best interest of the mortgagor. What matters is a proper price is obtained. So if you do no advertising, but it sells, at a really good price, well, you probably won't find a breach. And at the same time, a sufficient advertising campaign will not save the mortgagee from any other sort of impropriety in respect of the sale. In this case, the Westpac obtained a price of satisfactory. It outmatched even its own rival valuations. And you can also use this for the proposition that private sales are okay so long as the price yielded is satisfactory. Gold sell. This is your best or good faith case rather. The mortgagee sold the property through its agents to one of its best clients when there was another offer developing for a higher amount. And he didn't really let that offer come. He said, no, you must make the offer in 10 minutes or else we're selling or something like that. Leaving money on the table is inherently a failure to act in the mortgagor's best interests. You haven't secured the best price. Plus, doing that sort of sale, and then the recipient being your best client. Well, I think you can infer the ulterior motives there. Cool. Gus versus Geelong Building Society. Also, I'm really sorry this subject is we're not boring, but this topic is a bit dry. The property subject to the mortgage was in 2 lots, and the plaintiff argued that the property should be sold in 2 separate lots to achieve a greater price. However, the mortgagor sold the property in 1 lot as there was a dwelling on the property which touched on both the lots. This presents obvious difficulties to the plan to sell 2 lots because you'd be selling as 2 lots, and well, what are you going to do about that few centimeters of the dwelling on one of the other properties? That's not clean cut. The mortgagor alleged that there was a breach of the mortgage and the mortgagee should have done either one of the three following: apply to have the plots realigned, demolish the residence, offering the property for sale with the demolition clause. However, ultimately this argument was rejected The mortgagee paid due consideration to the mortgagor's proposals, but there was nothing requiring them to delay the exercise of their own security interest to the mortgagor's benefit. So, yeah, similar to the propitious time principle out of Henry Roach, I just went over. MBF Investments versus Nolan. MBF Investments was the mortgagee of property of Nolan. After protracted negotiations, the mortgagor agreed to subdivide the property into 3 lots, the mortgagee, rather, again. As part of this, it was resolved by the parties that the MBF Investments would have control over the order of sale. Nolan defaulted, and the MBF began the process of sale. Nolan was adamant that the MBF should sell the lots in the order he proposed. His ultimate aim was to keep the family home. The lot which had the family home on it. MBF initially sold one of the non-home lots when Nolan further pressed his demand that the house lot be sold last. However, MBF received legal advice that the selling of the home lot last would be fraught with danger, so they pressed on. Ultimately, because they had legal advice suggesting there was danger in entertaining Nolan's ideas, there was no breach of duty. MBF also had to consider the ability of second mortgagees who had interest over the property, so ANZ had a mortgage, I believe, to be paid. So the quote really that you need to know is that if there is no doubt the sale of the lots preferred by the mortgagor, Nolan, would be sufficient to discharge the debt owed to the mortgagee and any other security holders, a failure to sell in the preferred lots may be a breach. Not the case here. And if you have any sort of advice advising the mortgagee against, taking up the mortgagor's plan, they'll be okay. Finally, the practice problems. So have a read over these. Advise Ollie as to whether the default notice has been correctly issued. Presume for the purposes of your advice that the notice complies with formalities. Definitely do that. Answer. Consider whether presumption under Section 13.2 applies. So after all, the mortgagor has signed a declaration that the funds will be used for a business, which is a non-code purpose. However, it says that the bank deliberately does not probe further. And if they had have engaged Ollie in any sort of discussion about the purpose for the debt, they'd have realised the mistake, and that the purpose was more sort of nuanced than that. And a defective declaration means that this presumption will not arise. So you just consider whether it's a code purpose. 70% says is the predominant proportion of the funds is going towards a renovation of domestic property. This is a code purpose. So no dramas there. The code applies. Excellent. Now you move on to the notice requirements. So it's NCC protected. But remember, the serving of the initial default notice, the 76(1) of the TLA applies. In this case, they've waited 2 months. No problems. However, in the actual default notice, it says 10 days. Section 88.2 says that it must be 30 days. So, yeah, clear breach, power of sale has not arised. And, yeah, there'll be inequity, I think. Oh, no, they haven't commenced proceedings yet, so they can still stop. There could be an injunction or something. Cool, that's the answer for that one. These questions aren't too hard. Yes. Just going to read over this again and make sure I've done it properly because this is probably the main question. Cool. Is there any problem with the advertising? Now, do note that this is going to be a very factual exercise, like a very fact-specific exercise. Like you're going to have to play around with the facts. That's what I did in my exam. Not at all times are the facts going to line up exactly with the cases. Sometimes you have to use a bit of common sense, really. Is there any problem with the advertising? It's very local advertising. Why would you assume that the only people wanting to purchase the property would be from the ports he surrounds? What about the new money moving in? It's a valid point. However, the facts note that this type of advertising suits the unique and exclusive nature of the property. So that's also a counterbalancing factor. Have they obtained a satisfactory price? It has sold at a considerable undervalue, but this does not seem to be a result of the lack of advertising, but rather the fact that the market evidently did not want a dwellingless property. You compare it to Henry Roach, that the market didn't want a refinery. So lack of advertising probably is okay. The advertising is okay, I think. But yeah, you can come to whatever conclusion you like. Um, even if they had to spend more in advertising, advertised it widely, you come back to this point, the market doesn't want it. So they would have just been blowing money up the air. Come buy this property, no one wants it. So yeah, not really the advertising is the issue here. Is there a problem with the sale of the home lot? Uh, it's gonna be quite straightforward. After the flock that there was a vineyard, um, the bank is selling the home lot. And notably, they have taken actually, I think, yeah, they have taken account of what the mortgagor wants them to do, but they are selling at the amount which would see them quickly get paid out. If you look, they're selling at 500, which is pretty much exactly what they need. So that's improper in of itself, but like relatedly, they've turned down people willing to pay more, which is really bad. And the fact that there's a sale of this nature to the bank manager's best friend, who's responsible for running the sale, is evidently a breach of good faith. Oh, that is it. Bit of a shorter lesson. There's truly not too much to mortgages. It's a bit of a foundational topic for your later studies, so keep that in mind. But yeah, other than that, please reach out to me on the Facebook if you want some exam tips. For the upcoming class test. It's good to have it in the public space. That's the way I can respond to it. See, I don't mean to sort of flex, if you will, but I did quite well on the class test. So please ask me questions. I'm more than willing to answer. Anything. If you have a question about a point of law, how I think a certain case should be interpreted, how a particular fact in the scenario should bounce, which way it would sort of, what conclusion it would tend to. Whether I have any general study advice, please come and ask a question. You can do it anonymously. That way you can stay hidden so no one knows that you're asking a question, but still benefiting your fellow classmates, which I'm sure everyone wants to do. Yeah. But no, good luck with your test, because I take it you guys probably won't be watching my other lectures in the run up to the test. It's quite a far way away. So I think it's April 16th, I've heard. Do stay in touch with the content, because this is the nice part of the unit. The harder part conceptually is coming, I'd say. Sorry. But yeah, you want to stay in touch with the content so you can really pick up after that class test and get going. Thank you to those who attended live today. Just kidding. No one came. But please, I hope you enjoy the recording. Sorry about the last week's recording. There's a bit of a problem with it. That should be uploaded now. If not, I'll do it again. And this one will be up tonight. So good luck. Study hard. Tip. I put this in the Facebook chat, but no one seems to notice it. Do practice exams. There's three great conspiracies in life. One, we landed on the moon. Two, Lee Harvey Oswald shot President John Fitzgerald Kennedy. He didn't. And three, that university is oh so different to VCE. No, it's not really. You do the work, you do a practice question, and then you do another and another, and you'll find that you do pretty well. So hopefully that's some cool motivation. Go get them, and yeah, read the cases, etc. Please ask me questions. I'm feeling that I'm not providing enough value, so please ask. Okay, going to stop the recording. Thank you very much. Have a wonderful day. See you later.